Yes, welcome back again. Thank you very much, Mama Klangu. I quickly just want to read this powerful book, The Law of Damages, where the introduces Professor Klopper is an emeritus professor of private law at the University of Pretoria and has been a practicing attorney since 1973. Yo, that's a long time. Apart from lecturing in intellectual property, company law, and law of damages, he specialized in the law of third party compensation. That is the one that we are discussing today. Professor Klopper has published several textbooks and articles on the third party compensation, the law of collisions, intellectual property, and cyber law, to name but a few subjects. He is currently the leader of the Solution Task Team of the Association for the Protection of Road Accident Victims. Thank you very much, Prof. We have few books that Prof have just published. This one is the Law of Third Party Compensation, fourth edition. If it's fourth edition, we still have first edition, second edition, etc., etc. And I suspect that Prof is also writing new books as well. But I know that he wrote a lot of articles on the reviews. So, Prof, during our break, when we were busy with Mama Kangu, I received some few questions from our community of people that are always following us. One of the questions that they were asking is why I cannot claim from the wrongdoer directly, since the RAF have some problems in paying. It takes years and years before we can get our payment.
Well, there are two problems with that. First of all, the Road Accident Fund Act, in order to protect the road crash victim against the possibility that he won't be able to recover his damages from the wrongdoing driver, because the wrongdoing driver will not be in a position to pay, has excluded the liability of the wrongdoing driver. So Section 21 of the RAF Act says that the wrongdoing driver is not liable except for emotional shock in circumstances where the person who suffered the shock was not a victim himself, was not involved in the accident himself. So the other aspect is, of course, that should you do go the route of holding the wrongdoing driver liable, you could have a full-blown court case, get judgment against the person, only to find that that person is a driver, a taxi driver, and he works for the owner of the driver, and he lives in a small little house which he rents. He's got no other assets. There's no way that he's be able to pay. And keep in mind that the claims for injuries are in the hundred thousands of rand. That you will find that yourself be in a situation that you won't be able to recover your your damages from the wrongdoing driver. That's precisely why we have the Road Accident Fund Act. It's to protect the victim of a road crash against the possibility that he will be unable to recover his damages to which he is entitled in terms of the common law from the wrongdoing driver, because the wrongdoing driver happens to be a man of straw.
Okay, Prof. So it's like an insurance.
It was insurance to start off with. Initially, in 1946, when they brought in the system of protecting the road crash victims against the impecuniosity of the wrongdoing driver, they compelled people to take out insurance. So every year you had to take out an insurance. You had to stand in a queue, pay your money, and get a disc, which you had to put on your car as proof of the fact that your car is insured. And it was a criminal offence not to have insurance. So that's where it started off, and the people during the progression of the system, right from 46 up to now, in 1986 changed the fuel levy because it became too expensive to run it on insurance. You must remember that if an insurance company is involved, the insurance company is not there for charity, it wants to make a profit, and administering the insurance system costs a lot of money, up to 30% of each rand, or 30 cents of each rand that is collected. So if we had to change to insurance now, Every driver would have to put down at least 4,800 rand on the 1st of May every year, at least. It's going to be more than that because the 4,800 rand does not take into account the profit that the insurance company needs to make. So you can add at least a third on the 4,800 rand. It's going to be about 6,000 rand. It's going to cost each and every person to buy such insurance. And for the taxi owner, it's going to be something like 72,000 a year, which he has to put down on this. So what's going to happen in our situation? You're going to have lots and lots of uninsured vehicles, which is going to be a real problem.
Mm-hmm. One of the questions that I've received, one of the viewers saying, how long will it take for the RAF to pay my claim? I'm not sure whether you'll be able to answer that one.
Well, it depends on the type of claim that you submit. If it's a loss of income and loss of support, then it becomes a question of getting expert reports and things like that, and it becomes long drawn out. It should not take more than a year, but it takes up to 72 months. In extreme, other claims get finalized within 1 to 3 years. I saw the statistics on this, but I can't recall them at the moment. But it varies from 1 to 1 year, 12 months to 72 months. The ones that are 72 months are the very sticky and intricate and difficult ones.
That's very good. The other viewer asked another question. He was saying that can RAF pay any interim payment in case of the breadwinner died? And the RAF is still assessing his claim and they are suffering. The breadwinner is no more.
It depends on the situation which the claim has reached. If the merits have been conceded, then in terms of Section 17(6) of the Road Accident Fund Act, you can apply to the Road Accident Fund for a interim payment of the medical expenses and loss of income. But the problem with the loss of support is that support is at a stage that you are requesting and not being quantified. So that you can try and get it from a Road Accident Fund, but the chances of getting it are very slim. In fact, the case law seems to suggest that you can't get it for loss of support, only for loss of income and loss for the medical expenses.
That should be.
And then if you've issued summons and the RAF has conceded liability, then in terms of Uniform Rules of Court 34A, you can apply to the court for an interim payment, but then it will also be confined to loss of income and medical expenses. If you can settle the rate of maintenance with the Road Accident Fund and get an interim payment in that manner, probably at a pinch you will be able to swing it, but it's going to be a very difficult case to convince the Road Accident Fund that must pay you in advance on your loss of support.
Can the medical aid also claim directly from the RAF?
The medical aid is not a party to a crash. It is an extraneous party who's got a contractual relationship with the victim of a crash. So that the medical aid is not a third party. And the doctor that treats a victim is also not a third party. Because a third party, by definition, is a person who suffered loss or damage as a result of a bodily injury or the death of his breadwinner. That's the only person who is a third party. So if you do not comply with that definition, you are not a third party. If you're not a third party, Section 17(1) excludes you from claiming from the Road Accident Fund, because only third parties can claim from the Road Accident Fund. What the situation, the relationship with the medical aid is, the crash victim has got a contract. The contents of that contract is determined by the rules of that medical aid. So most of the medical aid rules will tell you that if you are involved in a crash, they have got a discretion to pay those accounts. and they will pay those accounts if you sign an undertaking that you will recover the amount from the road accident fund, and you will pay that whatever you recovered to them, whatever for the amounts that they've paid. So that's how that one works.
Okay. And I've received another question again. This question is very clear. The victim is asking, if I lost my child during the car accident and I suffer some psychological damages, depression, can I claim that directly from them, even if I did not witness the accident?
Yes, you can. That's emotional shock. But emotional shock, in terms of section 19G, is excluded from a claim against the road accident fund. If you're not a direct victim of the crash, you were not involved in the crash yourself, you cannot claim from the road accident fund. You have to claim from the wrongdoing driver. Now, I've already told you that's a problem, because most of the people that drive cars will not be able to compensate a claim for, say, 50 or 60,000 rand. So, in theory, you'll have a claim, but in practice, it might turn out that you'll have to spend quite a lot of money only to learn that you cannot recover that from the person that's responsible. And that's why we've got the road accident fund, is to prevent that kind of things. So it's quite ironic that the legislator now has put persons in a position that are not in the best possible position.
So the other question that I've received, these questions I just received from WhatsApp messages now. He said, I'm admitted in the provincial hospital and I'm not happy with the treatment, and it's very clear that the accident was caused by the wrongdoing of the driver. So he wants to know whether can he be transferred from the provincial hospital to the private hospital where he can get a proper.
Yeah, that's a very difficult question, because it must be quite clear to the provincial hospital that there was fault on the part of the driver. And that call is usually made by the ambulance drivers after they made a few calls. So you'll find that a person without a medical aid, as a general rule, will go to the provincial hospital straight away. If you can convince the provincial hospital to admit you, then so be it. They will admit you. But then, from their point of view, it is risky, because if it turns out that the conclusion was wrong, they cannot discharge you after they've admitted you. I had one hospital in Van der Bijlpark where it was caught out that way. They admitted the patient, and afterwards it appeared that the information they got was not right, and they spent 52,000, if I remember correctly, on that patient, and they had to write it off. So it's very difficult. The best advice that I can give: get a hospital plan.
That's the best.
If you can afford it, get a hospital plan.
And it's not very expensive hospital.
No. A hospital plan is affordable, so that if you've got a hospital plan, you're involved in a crash, you've got the peace of mind that you're going to get the treatment that you deserve. Because I can tell you horrible stories. I remember one case where one of my clients, his father, went for joyriding on a motorcycle in the Eastern Transvaal, and he went round the bend, and another taxi approached him on the wrong side, and he, in an attempt to avoid the collision of the taxi, he collided with the Onco barrier, and the Onco barrier cut off his little finger. Sure. So they called the ambulance, and this ambulance was Leidenberg. I don't know what the name is at the moment.
Was it the private ambulance?
No, it was the provincial. He didn't have a medical aid. So the ambulance arrived. There was no bedding on the dolly. He was put on the bed dolly, and was taken to the provincial hospital, and he put in the emergency section, lying on the bed. And the nurse came along, and he wanted to give him an injection for the pain. So he was lying on his side, and she was trying to inject him in his buttocks, and she misjudged, and she put the injection needle into the bed. So she pulled out the needle, wiped it on a uniform and try to inject him. So it's just there where my client and his father decided they're getting into the car, and they drove all the way to Krugersdorp and got admitted to a private hospital.
So, Prof, there's a issue of prescription. People think they can claim even after 5 years, 7 years.
The prescription is a problem. It's even a problem if you've got an ordinary claim. Even if you've not got a third-party claim, your claim is subject to a period within which you must lodge your claim. And the reason for that is in order to have a case where all the information is available and fresh, the law prescribes a period within which you must enforce your claim. And generally, it's 3 years. If you don't do it within 3 years, you lose your claim. Your claim becomes prescribed. And in the case of the road accident fund, it is also 3 years from the date on which you were injured or your breadwinner was killed or died. So with the death of the breadwinner, it can be the date of the accident or it can be later. Say, for instance, your breadwinner was injured and dies only 2 weeks later, then your prescription starts running from the date that he died, not the date of the crash. There is no condemnation for prescription. So if you lose your claim, you lose it. You've got no second bite. Even your claim against the wrongdoing driver falls away.
Sure.
There are 3 instances where prescription does not arise. If you are a minor, if you are a mental health patient, or you are under curatorship. Under those circumstances, prescription is postponed until that condition no longer applies. So if you're a minor, prescription starts running when you become a major, which is 18 years old. So if a child is injured when it's 13, prescription will only start running when that child turns 18 and will be completed 3 years after when that person turns 21. In the case of mental health patient, that prescription does not run. You have to be admitted to a mental institution, declared a mental health patient in order for you to have this cover. If you're not, if you're just mentally deranged without being admitted, prescription runs against you. That seems to be unfair, but that situation can be dealt with. Because you have not got all your facilities with you, you will not be able to deal with your third-party claim. Somebody will have to appoint a curator for you in order to deal with your third-party claim. Once a curator is appointed, prescription is then suspended until that curatorship is then discharged. Then prescription starts running against you again. So there are safeguards that safeguard people that are in special circumstances against the fact that they are in a position they can't enforce their claim because of circumstances. Then prescription is suspended for the duration of the condition which prevents them from instituting their claim.
There's another one, Prof, hit and run. How long must they supposed to claim from that? Is it also 3 years, the hit and run?
Hit and run is 2 years, and there's no suspension. So even though you are a minor, even though you are suffering from a mental disability, or even though you cannot institute a claim yourself, it has to be done within 2 years from when the date of the cause of action arose.
Sure. So thank you very much. I'm going to ask Prof some few last questions. Prof, what is your message to the public now who have lost their claim with the RAF and they're still waiting for their payment?
Well, if you've had a direct claim against the RAF and you're not getting any feedback from them, and you are scared that the matter is going to prescribe, you need to consult with an attorney as soon as possible.
Yes.
That's the first thing. Secondly, should you get a claim, an offer from the RAF, direct offer, my advice to you would be to spend the money, consult with an attorney, to get an idea of whether it is a claim that should be accepted or not. There are many people that accepted the claim of the RAF lodged the claim direct to the RF and accepted the claim, only to find out that they have been shortchanged, up to an extent of some of them R1 million.
Sure, sure.
One case that I heard of, the RF paid 400,000, and when the matter proceeded to court, it was settled for 1.4 million.
Sure, sure. And once the RF has paid, you can't go back. Once you accept the offer.
Yeah. Once you accept the offer, you have to be careful because a prescription runs against your claim against the Road Accident Fund for shortchanging you. You have to make certain that the RAF has not shortchanged you, and there's a duty on you to do so. If you do not do it within a reasonable time after you became aware of the fact that you've got a claim against the RAF because they paid you too little, then that claim will be lost. I can remember a case of Mr. Kgaka.
Mr. Kgaka, yes.
Mr. Kgaka, he saw in the paper that other claimants got more when they went to attorneys, and he went there, but years and years and years after he got paid. And the court said, but he should have, being a policeman, been aware of the situation, and he was supposed to know that he had a claim far earlier than he admitted, and for that reason he lost his claim for the difference between what he got and what he would have been entitled against the Road Accident Fund. When you institute such a claim, then the RAF Act is not applicable. So all the provisions of the RAF Act do not apply to such a short paid claim against the Road Accident Fund. It is a delictual claim for damages that you institute against the Road Accident Fund.
Okay. So let's say, for example, you lodge a claim with the RAF after 3 years as well, there's no payment. Can the claim be scrapped?
Then you must, if you've got a claim with the RAF, if you hear nothing from the RAF, you should consider doing something about it. You get no answers from the Road Accident Fund, you get no response from the Road Accident Fund, you should consider doing something about it. I've seen a document which was in 2014, I think, 13, 14, round about there, where a figure of 25% of the claims that the Road Accident Fund do directly become prescribed.
Sure.
That is a figure that I saw in an internal memo somehow, but that's a figure that I heard. I don't want to say it's 25,000, but there are a considerable amount of claims that are subject to prescription in the hands of the Road Accident Fund. So you need to make work of that and get somebody to follow up or get your file or do something about it, even way before the 3 years are over, so you can ensure that you don't lose your claim. Because now that when you lose the claim, it becomes complicated, because now you have to sue the Road Accident Fund because of their negligence, and they're not going to admit that they're negligent, because the person that dealt with that file, his job is on the line. And you can understand that they're going to resist that claim as far as they can.
Prof, others they say we can't go to the attorney for RAF because the attorney are very expensive. Can you just explain to them that they don't need to pay for it?
You know, attorney is a businessman also. He has to pay his staff, he has to pay for the rent of his offices, he's got expenses. And when you approach your attorney, I think the first thing that you are entitled to do is to negotiate a fee with that person. So you don't need to pay whatever attorney asks. If he's not prepared to do the work for the fee that you're prepared to pay, I think you should consider not briefing in the first instance.
But Prof, I wanted to talk about the contingency fees agreement as well.
Yeah.
Like you don't need necessarily to have the money at hand when you go to see an attorney. You can agree on percentage that you pay.
Yeah.
The attorney will get paid.
You see, in some instances, the cases of such a nature that one has to disburse monies up front. And the majority of the claims, if not all of them, have not got the funds to do so. So you need, for instance, a medical legal report. In order to get a medical legal report, you're going to pay anything from 5,000 to 15,000 rand for a medical legal. Some of the doctors expect to be paid up front.
Most of them, yes.
You get doctors which can work on the basis that they get paid once a claim has been finalized. Now, I always use those kind of doctors because they're my kind of doctors. Once I had to get a claim, a medical legal report from orthopedic surgeon.
Yes.
He charged me 15,000 rand, and it was a copy and paste. I was not happy. Really, I had to pay it out of my own pocket. And when the claim got finalized, I got my money back. So from the period that you disburse the money up to when you get it back, you carry that disbursement, and you can get a situation that all these specialist reports can be up to 100,000.
Sure. That's correct.
In a big claim. So the attorney renders a service by financing your litigation, and in return for the risk that he runs, he charges an additional or a higher fee, a higher than normal fee. And that fee is governed by legislation. As we discussed before, you cannot charge more than 25% or double his normal fee, whichever is the lesser amount.
Correct. So
the higher the amount that you recover, the more unlikely it is that it's going to be 25%, because the 25% is going to be much more than double the taxed fee. I had one of my students who had a claim, and this attorney took 25%. And eventually the student consulted me, and we issued summons against the attorney. He overcharged it by a considerable amount, and we got the majority of that amount we got back from that attorney, because he did not have a valid contingency fee agreement. He thought he had, but he didn't.
So Prof, some of the people, they have their claim been finalized, they've been paid, but now they are stuck with the so-called undertaking certificate. What is the
undertaking is a problem. It should not be in our system at all, because the undertaking presupposes that the claimant must pay and then afterwards recover from the road accident fund. There's another way of dealing with that is, in order to get your treatment that you require, is to negotiate with the medical service provider and say, listen, I want you to claim direct from the road accident fund. So please approach the road accident fund to pre-approve the procedure, and then that they will accept your claim and pay you direct. But most of the medical people do not want to do that, because they know they're going to wait up to 2 years to get paid.
So what is it? What is this called undertaking? It's like a undertaking.
Yeah, but you see, when you suffer future damages, either for medical costs or for loss of income or loss of support. In the one case where it's medical costs, the RAF, instead of giving you a lump sum to cover your medical costs over the period that you required, can give you an undertaking. And that undertaking says that they will pay for the costs as and when it is incurred, provided that the costs are within the parameters of the injuries that you sustained and are a consequence of the crash that you were involved in. Now, that is a problem, because in many cases the road accident fund says, but this is not crash related, so we're not going to pay.
It's a challenge.
And for that reason, an undertaking, as far as the majority of the claimants are concerned, sucks. Because they are expected to pay first, and then when they issue, then they get hassled. They get paid, and it takes ages to get the money out of the road accident fund as well. And with the other one, where you have got loss of income or loss of support, then you can, if you refuse to take the undertaking, then so be it, they must pay you in a lump sum. Recently, with medical legal claims, there's been a move afoot to postpone the payment of the claim in installments. But I see that the bill is now being sent back to Parliament as being unconstitutional. That's a problem because the common law rule is you must get your payment on the cash, the lump sum. And the reason for that is that so that the people can get rid of each other, that there's not a continual litigation on you owe me the money, you're not paying, I'm suing you for the money that you owe me, etc., 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 etc. If I had my way, I would take out the undertakings clause out of the RF Act and get another way of dealing it with. Rather have use a supplier, approved supplier way of doing it. You get suppliers that are approved by the Road Accident Fund. A person can go to the supplier. The RF will pay. If he wants to go to his own doctor, he must pay, and then he can recover from the Road Accident Fund.
No, thank you so much, Prof. Prof, there are some young people who want to become an active. Do you think it is still a room for young people to take this profession?
I became an attorney for one reason. I had a clear idea of what I wanted to do. I wanted to become a lawyer, and I wanted to deal with third-party claims. That's what I wanted to do. I wanted to vindicate myself for the fact that I did not receive my compensation. At that stage, I was 13 years old, and I had a picture in my mind of this new sport bicycle that I'm going to get. And when I got nothing, I was very, very disappointed, even up to now. And then the second claim that I had is I worked at attorneys in school holidays, and I had lunch at home, and I was on my way back to the office on my scooter, on my motorbike, and a guy skipped the stop road. I broke my upper leg, spent 6 months in hospital. And when my claim had to be finalized, the insurance company had become liquidated, and I got 50% of my claim. So you can understand, well, I've got considerable enthusiasm for this subject. I think that if you are hardworking and you don't mind a measure of slogging, routine work, and you like making a difference in the lives of person, becoming a personal injury lawyer is very rewarding. And not only on a spiritual level and on a personal level, but also it can be rewarding on a financial level as well.
No, thank you very much, Prof. Thank you so much.